to another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
Hey, what's going on, guys? I'm attorney Michael Ehline, and as you guys know, I am an attorney licensed in California and Texas, and I am here today on President's Day to try to teach you all how to do a police deposition for pro se idiots or pro per idiots. And when I say idiots, I mean that's a term that was coined, I believe, by Lane Myers and Reluctant Prophet on what the government calls people who try to represent themselves. And so obviously there isn't a lot of pro per or pro se deposition stuff that's on YouTube. So I'm just going to teach you what I know. I've done thousands of depositions in my 20 plus years in practice. And prior to that, as a certified law student and a paralegal, I also worked on preparing deposition questions and learning the rules of evidence. So I've got a lot of cool stuff that I want to share with you today. So hopefully you guys can hear me and understand what I'm saying. I've been out with a serious back injury for the past couple of days, but I'm back. I got this really cool chair that lets me fold my legs under, and that really helps a lot. So I'm going to try to stick it out with you. Hey, what's going on, Brent? I'm glad you joined me, bro. Outstanding. Everybody give me a bunch of ones for Brent, even though he's the only one in the chat today. And look, I know it's President's Day, so I know there's probably not going to be a lot of people, but it would be really helpful if you can double tap the screen, because we're in vertical mode, and hit that like and subscribe button and give me some love. And I'm going to try to start doing my shows again on a regular basis. Tomorrow I have to get an MRI, so I may not be live just because of the time constraints. But, you know, I got kind of burned out on just showing police attack and police body cam videos, because I just don't really feel like it's teaching you guys a whole lot about the law. And as a lawyer and somebody who became a lawyer on the law study program in the traditional way of becoming a lawyer before we had these Marxist-run political indoctrination camps that they call law schools, I became a lawyer in the old way, which is where you study under a judge or a lawyer, and then you earn your way into the bar that way. So, hey, what's going on, Brandy? Super glad to see you. I'm really glad that you're here. So I've been out with my kids today. Since we have a sibling rivalry, I had to take my daughter out shopping first, drop her off, and then come and pick up my son. But I've been teaching my son how to do street surfing, aka skateboarding. I used to be like a semi-pro skateboarder when I was a kid, so I'm teaching him, how to skate goofy foot and how to drop in, how to do kicks, how to pump, and all the cool stuff. So having a good time doing that, bringing back a lot of memories before I had all these responsibilities, when Dad and Mom were never around, and I just got to go out and get crazy on my skateboard down at the Blowhole in Yorba Linda. And you in Orange County remember the Blowhole? That was always fun. Listening to the Sex Pistols or some cool punk rock, the Clash or some Dead Kennedys, little GBH, getting crazy with the big old ghetto blaster and the cassette tape. I don't know if you guys remember that. But yeah, Brandy. So today we're gonna get into a little bit about how to do a police deposition. And so what we're going to cover today is the Aviana Bailey versus Daytona police case. And even though this isn't a pro per case, it's a case involving a police abuse, and there's a pretty nice transcript, and there's some news. I wasn't able to find the actual body cam footage of the actual shooting, but I would imagine there's so many cuss words and other things going on that I would get copyrighted or some kind of a strike from YouTube, because they don't believe in free speech on YouTube, really. So I'm doing my best to try to work within their communist Marxist parameters that they have. Just Willie, Dr. Walter, you too, Doc. I'm glad to be here. So I got this really cool chair. Hold on, I'm going to show you really quick. I'm going to try to hold it up. This has really worked like wonders for me. In addition to a standing desk, I got this really badass chair. I don't know if you can see it or not, but it's like you put your legs like you fold your legs under, and it's really awesome. Man, I hope I didn't throw out my back just now. But it's super lightweight. It's really light. And so I can fold my legs under, and that prevents my sciatic nerve from getting pinched off. And it just feels amazing. So basically, like my shins are on this pad, and then I'm sitting in this cool chair, and it really helps a lot. So I'm hoping that that'll help me get my shows going again, because I miss you guys. I'm down from 1 million views to like 600,000 views, believe it or not. So obviously I'm not getting a lot of views because I'm not going live. So, and I really like, being a jarhead. I got to win. I got to have those views, it motivates me, so I'm going to try to keep it going for you guys. What's up, Cammed Up Caveman? Brent Shimko, Dr. Walter, you guys are all so awesome. I'm so glad you're here. So really quickly, I'm just going to tell you about this case, and I'll share the screen with you. Hopefully you guys can see it. So this is a case involving a woman who was paralyzed in a police shootout, and her name is Aviana Bailey. And I'm not going to make a judgment call on whether or not the cop was in the wrong in this case. I mean, it appears as though there was some kind of a situation where there was a traffic stop and her boyfriend pulled a gun on the cop. And we're going to find that out at the deposition in a few minutes. So be prepared for a long show tonight, guys. Like, get your popcorn or whatever, get plenty of water, food, because you'll have much more fun here than the Communist News Network or PMSNBC, right? Because we're just going to tell the truth. I don't accept money from corporations or political parties. This is a donations only channel from members. So if you want to throw a super chat or you want to buy memberships, I'll go ahead and put you to the front of the line to answer any legal type questions with respect to what's going on with the rules of evidence in either California or Texas, and then general legal principles. I'm not going to give legal advice. I'm not practicing law right now. I'm just teaching you what I know from a perspective of what I would do if I was in California or Texas. And obviously, if you're going to do your own case, you're going to want to hire someone, a lawyer, or make sure you really know what you're doing. So this is just my opinion of how I would handle a deposition, but I want to lay a foundation first. So hopefully you guys understand a really good lawyer will always lay a foundation before we start talking out our butt. So let's lay a foundation really quick. That's right, Dr. Donna, ergonomically correct. All right, so this article is from August of 2014, so it's older, but it was the best thing that I could find that had good stuff. So you can see that this woman, Aviana Bailey, she's sitting here in a wheelchair, and I believe that's her daughter. That I don't know if that's the one she was pregnant with, but she's sitting outside her father's home in Melrose, Massachusetts, as her 4-year-old sister, it's her sister, Neela Jones, runs around. And Bailey was paralyzed by a ricocheting bullet of a Daytona cop. So Aviana Bailey said she didn't hear the shots and didn't see the muzzle flashes, but she saw the cop with a Glock leveled at her boyfriend as he sat in a car. She felt her life change as that .40 caliber bullet slammed into her chest. So she said, "I felt the impact of it," Bailey said. "My whole body went numb. I knew something was wrong, and I just see him with his gun pointed at us." She was paralyzed from the chest down after the shootout. So there was a shootout, like an exchange of gunfire. And the state attorney general's office cleared Officer Messerow of any wrongdoing criminally. We'll get into that in a minute, the difference between civil and criminal. The 25-year-old Bailey is able to breathe, but she can't use her arms or legs. So that's terrible. I mean, quadriplegia it's like a death sentence. I can't even describe. I've represented several quadriplegics, and it is just the most horrific thing you could ever think of. Hopefully you guys can hear me okay. Anyways, it's kind of an emotional story, whenever you hear somebody like even if they're at fault, I mean, come on, what, paralyzed for life. And this one she was just there at a crime scene. The doctors decided not to remove the bullet, which damaged her spine. So she still has the slug inside of her. She's not able to care for her child, who will turn 2. So she was able to give birth, it looks like. Oh, wait a minute. Nope, she did. I don't have my son, she said. My son doesn't have, right. My son doesn't have me the way he needs me. So her child, she did have her son. She carries around guilt because she said her son had to be weaned off the pain medication she was given when she gave birth to him. So apparently the son was addicted to the pain medicine. That's terrible. Gosh, that's awful. Imagine being born addicted to pain medicine. And he'll always have that in his brain, that addiction. So if he ever does take a painkiller, he'll probably get highly addicted. That's awful. So she's confined to a wheelchair from the waist down. She doesn't work, but her attorney says her attorney John Phillips. Let's see here. So it's virtually impossible to care for a child. The police chief has declined comment. The woman who answered the door of her home referred the questions to Bruce Brogan, her attorney. So give me a bunch of ones for Bruce Bogan for taking the case. Bruce Bogan, Bogan. Let me see here. Bogan argued that Mesereau had qualified immunity as a police officer because he was acting within his discretion. Okay, a woman who answered the door referred the questions to Bruce Bogan. So Bruce Bogan represented the police department, and he's claiming the cop has qualified immunity. He argued that police officers have to make split decisions, and this is a federal case. The 11th Circuit Court of Appeals has said that it should be reviewed with an appreciation towards real-life conditions. We must see the situation through the eyes of the officer on the scene and who is hampered by incomplete information and forced to make split decision between actions and inaction. Well, you guys know how I feel about that. I mean, I don't think we need road pirates pulling people over to begin with. So I definitely part ways there. Anyways, a federal judge dismissed Chitwood in the department from a lawsuit, but Phillips, the same attorney who won a $2.6 million verdict against Volusia County woman in Kansas, said the lawsuit will be amended soon to add the city of Daytona Beach as a defendant. So I don't know what the outcome is of this case. I'm just laying a foundation because I'm going to teach you how I would handle a deposition of this cop. And I'll let you know if I think that the attorneys did a good job in proffering the right questions and the right objections as we go through it. Bailey's lawsuit says Mesereau fired between 23 to 37 bullets, and two other officers fired 5 times. The investigation also found that Jones, her boyfriend, tried to fire his guns 6 times, but it malfunctioned and only fired twice. Jones was hit by 5 shots. Man, that cop is a crummy shot, right? No police officers were hit. Go figure. And Jones pleaded no contest last year to attempted second-degree murder, resisting arrest, and attempting to elude, and he was sentenced to 30 years. So apparently he survived. That's interesting. And then, of course, the state attorney general cleared him. And so what happened to Jones is separate and distinct, according to the Phillips, her lawyer. And he says, now we need to figure out what really went down. And at no point was Aviana more than a girl who was pregnant, going to see the father of the child, not knowing anything was going on, and winds up with a bullet in her spine and paralyzed. The suit claims that Mesereau fired in an unsafe and unreasonable manner, and that could very well be. And we're going to find out during the depo. We're going to let you decide. You're going to be the jury. The events changed her life. Happened on April 28th, 2012, minutes after she landed in Daytona. So I think she was coming in from another country. Jones was waiting for her with a gift and a pair of brand new Nike Jordans. Wow, sounds like a really classy guy. Hooking up his woman with some Nike Jordans. Damn, dog, that's dope. And he had bought me some sneakers because I have a thing for sneakers, she said. That's pretty cool. So they kissed and hugged, and then Jones got behind the wheel of his Lincoln, and she got in the passenger seat. And the police received a call about a man in a gold-colored Lincoln waving a handgun in the airport parking lot. Well, he did have a handgun, so there's a high probability that, by the way, open carry is legal in Florida, from what I know. I don't know if it's legal at a federal airport, and I definitely know it's not legal to wave one around, so I'm not sure what happened there. Anyways, after that, Marvin was pulled over, I guess, and the officer said he wasn't going to repeat himself. He told him to get out of the car. Jones drove off, but the Lincoln hit some spikes, and the tires were flattened. He lost control, spun 180, and stopped on Richard Petty and faced Mesro, who responded to the airport with other cops. And he was in full uniform. He advanced on to the driver's side door and ordered Jones to show him his hands. Jones was moving in his lap. Mesro said Jones' eyes became very wide, and he pointed an old-style Western revolver at him. And that's when the shots started firing. So I don't want to get too much more into it. I'll play this video from the news, and I'll let you guys sort of watch what happened. Kind of let you guys, we report, you decide kind of a thing. So here is the video.
You see, she's now paralyzed, and her attorney claims it's all because of negligence. Aviana Bailey was pregnant with her son when she was shot in 2012. FDLE cleared Officer Joshua Mercero, who agents say fired at Marvin Jones at least 28 times. Jones pulled out a gun on a police officer and fired twice, but Bailey's attorney says Mercero fired back as he was tripping over a curb. Bailey was shot in the chest, but she and her son survived.
Oh, that's wild, man. Jiminy Christmas. So I have a 13-minute interview with the cop. I'll just play it for you. So at least you'll understand what he said soon after the incident.
We are now recording. Today is Tuesday. Oh, I'm sorry. Today is Wednesday, May 29th, 2013, and it's approximately 9:50 a.m. This is Detective Nate Williams of the Office of Professional Standards. This interview is taking place in my office here at 129 Valor Boulevard and is in reference to case number CC 2013-007. Present with me is Officer Joshua Mercero. Officer Mercero, a moment ago I read to you a form called the Internal Investigation Pre-Interview Notification Form. Is this your signature here at the bottom?
Yes, sir, it is.
All right. Officer Mercero, can you raise your right hand for me? Do you swear or affirm that the testimony you're about to give here is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All righty. Officer Mercero, this case is, or this interview rather, is in reference to an incident that occurred on April 13th of this year.
And by the way, just really quick, so you know, like typically after a incident like this, Internal Affairs will automatically place the officer on leave and do a recorded statement under penalty of perjury. This is not the deposition. This is just the recorded statement. And typically they'll try to say this is privileged and not allow me to have access to this before I take the deposition, which is really crappy. So, because it makes it really difficult for me to cross-examine and impeach a witness if they change their testimony later. So there's a whole process to this, but we'll walk through it. By the way, guys, this is going to take a while. So, try to bear with me and be patient. This, I can't build Rome in a day because I'm trying to teach you guys how to object and how to properly question someone at a deposition. And the way we'll do that is to lay a foundation first. Let's go.
Shortly after midnight at the Ocean Deck, you recall the incident that I'm speaking of?
I do.
Okay, if you would, tell me how it is that you became involved in this particular case.
We got dispatched there. We were actually attack unit that night, working a overtime operation, a JAG op or a TNT op, and we got dispatched there in reference to a physical fight.
Okay, and what happened? What happened once you arrived on scene?
When we got there, we spoke with the manager. He advised that there was 3 individuals at the bottom of the stairs, 2 males, 1 female, and they were being physically aggressive with other customers and their staff.
Okay, when you say we, who else was with you on that?
Pardon me, Officer Jack Murray and myself.
Okay, Officer Murray and yourself. Was anybody else, any other officer there at the time that you guys arrived and made contact downstairs?
No, there wasn't. It was just me and Jack Murray.
Okay. Once you got downstairs, what did you walked down the stairs with the manager, I take it?
Correct. He had portrayed to me, or he had communicated to me, that the three had to go. They were trespassed. He didn't want them there anymore, and they were trespassed.
Okay, so I'm taking it that he pointed these people out to you.
Yes,
and that's how you knew who to contact.
Yes,
or make contact with.
The bouncers did. Yeah, at the bottom of the stairs.
Okay, once you made contact with this group, tell me what transpired then.
Well, we tried talking to him. Jack did. Jack initiated a conversation with a fairly tall black male, tried to get the story, what was going on. He didn't want to hear it. If I may add, that all this was caught on video, as you know, my body cam. He tried to get to the bottom of what was going on. He tried to talk to this guy about the situation. The female stepped up. She said she called 911. So in the process of trying to get to the bottom of the story of why these people were being physically aggressive toward the staff, the ocean deck staff, things just got out of hand.
Okay. And when you say they got out of hand, what exactly?
By the way, guys, because we're in vertical mode, I really appreciate if you'll support my channel by double tapping the screen and giving me a bunch of likes and subscribes and saves for later. Since I'm not in horizontal, I'm trying to appeal to people who use handhelds by filming in vertical. And so I know it's more difficult to like, subscribe, and save, but please do so, because it's very difficult for me. I've been practicing law for about 20 years, and I'm trying to build a YouTube presence. I'm trying to show my wife and kids, that this is a cool way to get other people to learn about the law and to help other people and to be courteous and kind to others. So be courteous and kind back, and give me some likes and subscribes, and throw me a super chat or buy some memberships, become part of Team MPE. I'm going to be coming live a lot more in the future, and I really want to help people, but it helps me a lot if you can support my channel. So let's keep it going.
Are you speaking of what actions actually were?
The tall black male was starting to get physically aggressive toward who I don't even know. I think it was a bouncer that was behind us that we talked to after the fact. Mm-hmm. Officer Murray told him to stop pointing, stop reaching across him, at least twice. As we were trying to talk to this black female, which they turned out to be husband and wife or girlfriend, boyfriend, we were trying to talk to her. He reached across Jack again, and Jack told him, would you, it was getting to the point where, something had to be done. He told him to stop a third time or a second time. I think it was a third time. It's on the video, and I can't remember if it was second or third. He reached out and pushes Jack, kind of hits him in the shoulder, like he wasn't going to stop. So at that point, I took him to the ground. I initiated contact, put him on the ground, and put him in handcuffs.
So what you saw from the complainant in this case, Mr. Johnson, was him. He made contact with Officer Murray.
Yes.
Okay, and what did that make you feel, or how did you perceive that?
I felt like we needed to intervene. I felt like I needed to intervene. Like we needed to put this guy in handcuffs to kind of if nothing else, make him pay attention to what's going on. Like I said, he reached out and pushed Jack like he wasn't going to listen to anybody. I didn't see the situation going anywhere but downhill from there. So okay. I did what I did.
Did you think that to be a safety issue?
Absolutely.
Officer safety issue?
Absolutely.
Yeah. Okay. What else happened after that, Officer?
I went ahead and put him on the ground. It was nothing violent. It was more of I grabbed him by the the right wrist, in the back of the shoulder area, got him to the ground. He didn't give much resistance. At that point, there's another male there and another female, and the female who was starting to walk toward us. So I looked back and engaged them and told them to back up.
And that's when you disengaged him and,
Yes.
and went to the crowd.
And was more concerned of the crowd, and if I didn't want anything really to happen with taking this guy in custody. You don't want to take a bottle or a boot or something. I just didn't want to any chances. Like I said, he wasn't resisting. He wasn't offering much resistance at that point. So Jack could handle it. I knew Jack could handle it, so I went ahead.
And again, for those who are joining us, I'm laying a foundation right now. I'm going to teach you guys my knowledge and skill in objecting and asking proper deposition questions in a civil case. And so this is a case involving an officer shooting where Officer Mesro of Daytona Beach Police shot a woman's boyfriend who allegedly drew down on the cop, but the bullet ricocheted and lodged in this woman's spinal cord while she was pregnant and ended up causing her to be a quadriplegic. And I'm not making a judgment call on, whether the cop was right or wrong. That's for you to decide. I'm going to be neutral and just get into laying the foundation so you know what happened, and then we'll get into the actual deposition and how us lawyers handle depositions.
And turned my back to the suspect and Jack and dealt with the female and the other male. Told him to back up.
Okay. All right. What happened then?
At that point, I heard Jack struggling, and this guy apparently, at that point, it kind of escalated. He started resisting and didn't want to put his hands behind his back. It wasn't a huge deal. Jack regained control of his hand, and we got him in custody.
Okay. And what happened? What happened from there?
At that point,
What's up, Beth?
things had kind of cooled off a little bit. Jack stood the suspect up, started walking him out. I made contact with the bouncer. It was loud down there, so we wanted to get out of there. We wanted to do our investigation up on the blacktop, up on the in the parking lot, so we could hear each other. So Jack moved the suspect out. At that point, I contacted the bouncer. Contacted me and told me that the black female had punched him and jumped on his back, assaulted him, or committed a battery. So at that point, he advised that he just wanted him trespassed. He didn't want any charges pressed at that point. So I told the one black female and the other black male that was with this other guy, let's go up the stairs. Mm-hmm. So we all went up the stairs and went out to the car. Went out to the awaiting patrol office on Ocean Avenue.
Okay. What happened from there? Once you got up top, what happened from there as far as this incident?
This guy, I don't think he said he was from the Bahamas. Well, he couldn't understand why we put him in custody for putting his hands on a police officer. He didn't understand that.
Thanks, Beyond. Thank you, brother.
And then I tried to settle things down and talk to his wife about things. Mm-hmm. And I hope that's on video. I don't know if it was loud and I couldn't hear it beeping. So, but I talked to her for as much as 10 minutes, trying to explain to her what happened, why we did what we did. And she commenced to try to explain to me that that's not the way it is in the Bahamas. The police don't do that in the Bahamas. She gave me a pretty good explanation on what things transpire and how things are in the Bahamas. And I tried to explain to her that she's not in the Bahamas. She's in Daytona Beach.
Just as an aside, he does have a valid point. However, under English common law, I will note that the English courts would consider a Scottish law or Welsh law, like the laws in Wales, when they were trying a case in England against someone from one of those countries. So there is actual legal precedent or legal precedent, if you prefer, to under a common law, part of the English common law territories, and I believe that the Bahamas are part of the English common law. Of course, we're American common law, so it may not apply for us, but just to kind of let you know that there is some precedent for that to apply. And since we are American common law, unless that would abrogate our constitutional law system, it could potentially be a valid basis. But the issue is did the cop know, right? And obviously, if what the officer is saying is true, I mean, the guy pulled the gun on him, so probably the cop had the right to shoot back. But probably, I don't know, firing 30 or 40 rounds may not have been the best choice in this case, because a woman's paralyzed for life. I don't know. What do you guys think? I want to hear what you have to say in the comments.
No, we need to maintain a certain level of order, and that's why we did what we did. Like I said, we had a civilized conversation between me and her as to what was going on after he was in handcuffs. Mm-hmm. And I tried to explain to her the bouncers. Apparently, this whole situation stemmed from the guy that was in custody. His friend was throwing up all over the bar. Apparently, he was so drunk. That's why the bouncers grabbed him and wanted to throw him out. So that's how that fight began with the bouncers. And I told them that I tried telling her that the bouncers can refuse. I tried to bring it down a level and explain to her what was going on and why we did what we did. Like I said, I had about a 10-minute conversation with her, and she just wasn't hearing it. That's not the way it is in the Bahamas, and that's why he acted like he did. So I guess, and in the end, we agreed to disagree, but he was still going to go to jail.
Okay, now at the point you guys had got back up top on the hard top, or getting ready to make the transfer, get the suspect into the patrol vehicle.
Yes.
At that point, was he still cooperative or belligerent, or even though he was in handcuffs, how was the scene up there?
He was still argumentative. He was never any more physically.
So Ronald Stewart asked an interesting question. Does a law enforcement officer have jurisdiction inside of a private business? And so the way this normally works is it's kind of complicated, but it's kind of not. When you have a business, you also have a license from the state or the local authorities. And that basically gives the state or local authorities an easement to be able to enforce laws within that jurisdictional area. And in particular, if a business owner has invited someone in, it's sort of like Count Dracula, you invite them into your house, right? In that case, that would imply that law enforcement does have authority to enforce the local statutes and codes. And that has been tested, and most courts have found that is a valid use of law enforcement authority. However, at post offices, it's a little bit different. Unless the post office has actually given the police local authorities to enforce federal law, they do not have jurisdiction. And so it's really hilarious hearing these people who think they know about the law say that it's okay for local cops to come into the post office. They're not even allowed to bring a firearm into a post office. They have to have some kind of an agreement beforehand. And also the local police have to have a way to get reimbursed for enforcing laws in a federal territory or enclave. So that's a really great question, Ronald, and I really do appreciate that. And if you have more questions, let me know. And again, super chats go to the front of the line if you guys have questions. I haven't been online for a couple weeks now, so I haven't gotten any donations to the channel. And obviously my wife's a penny pincher, so she's like, man, you got to get back. Like, I can't even walk, babe. Come on. Anyways, here we go. Let's listen to the rest.
He never got any more physically aggressive toward us, but he was starting to be. He was very argumentative. At one point he became, I don't know, I guess you call it babyish. He just, like, he's passed out, like, not physically resisting us, but passively resisting us. He didn't want to stand up. He just just like acting like he was passed out, which he wasn't.
Okay. Did he get in the car willingly or?
I'd have to look at the video, but to the best of my recollection, there wasn't anything. Like I said, there might have been some passive resistance, like he didn't want to put his foot in, or there was never any physical, aggressive, not wanting to get in the car. It was more passive, like just letting his body weight go and acting like he was passed out.
Alrighty. Officer Mesereau, is it anything else that you can recall that we have not discussed from this incident?
No.
All right. Now, just to recap on what we've spoken about, when you were downstairs, you felt as though there was an officer safety issue with Mr. Johnson reaching or touching or grabbing or pushing. I don't know exactly what your terminology was in that sense, but when he made contact with Officer Murray, you felt as though that was an officer safety issue and you had to step in at
Potentially.
that time.
Yes, sir.
Okay.
Yep.
Alrighty. Have you made any contact with either Mr. or Mrs. Johnson since this incident?
No, I have not.
You haven't heard from them telephonically?
Nope.
Nope. Okay. All right. Very good. You have any questions for me?
No, I don't.
All right. If that being all, it's approximately 10:04 a.m. And this concludes this interview.
All right. So what you just heard is oh, thank you, Brett. Hey, everybody. Give me a bunch of ones for Brett, gifting 5 memberships. Hopefully Brett's memberships will get to people who want to be part of Team MPE. And so my goal here is to teach you the law, to teach you the Constitution and the Bill of Rights, but more importantly, to teach you the principles of natural law, which is where American common law really comes from, which is that all of our rights come from an all-powerful creator, and because of that, they cannot be stripped away by the government. They are unalienable, and words mean things. And so the modern-day leftists and Marxists hate that about our country, and they've done everything they could by controlling our banks, controlling the corporations, and controlling the news media until just recently we finally got X and a few freelance news stations. But they've done everything they could to destroy the concept of God, the concept of a creator, to mock you and make fun of you if you believe that your rights come from the universe, because they want you to believe that your rights come from man. And why is that? Because if your rights come from man, they can be restricted and be liened. Unalienable, L-I-E-N. Remember that. It's a lien upon your rights. And if it's unalienable, your rights cannot be liened. And so words mean things. I just want you to understand that. Most lawyers don't know any of this because they don't teach you that in law school. You really have to be a legal historian and a constitutional law scholar to really know what you're doing. Anyways, so that was the Internal Affairs initial investigation. I don't know how they were able to get that report. And by the way, I'm only licensed to practice law in California and Texas. So when I talk about depositions and things of that nature, I'm either talking about how I would do it in Texas or California, or I'm talking about general legal principles. I'm not giving you legal advice. I'm simply telling you how I would handle it if I was a pro se idiot, as Lane Myers or a reluctant prophet would say. And by the way, give me a bunch of ones for all of our patriotic YouTubers out there like Lane Myers, Reluctant Prophet, Chili DeCastro, and others who are out there hustling to try to make it happen and teach us the law. And again, thank you again, Brett Ray. It really means a lot to me. I'll let my wife know that at least somebody donated some money to my channel tonight. That really means a lot, man. You're awesome. Hey, Salt Shaker, good seeing you. You rock. Oh man, that's so cool. I got hold on a minute. I got a cool bunch of I got Salt Shaker, Selwyn, all my buddies came back. Thanks, guys. I've been out with a really bad back injury, so it really means a lot to me to see you guys. Mr. Osgood, good seeing you. Beyond Watcher, bunch of ones. Michael J. Quintana, good seeing you, homeboy. Right on. Super happy. The Chosen Ones. Era! Freaking the chosen ones, the chosen few. Age Go, good seeing you, Age Go. Kevin Brunarski, my homeboy, man. All these cool dudes. 6'9", you can ask questions and I'll do my best to answer them, but I'm really this is a really long deposition. So I'm gonna, probably have to like try to answer stuff like as the world turns, as they would say. So let's get into the deposition of this officer. And what I'm gonna do, well, actually, you know what? Before I do that, here's what I'm gonna do. So I'm going to tell you the types of objections that can be made at depositions. All right. So typically you can object to form, and this is California. Okay. But it's pretty much universal, and from what I've read. But you can object to questions that are compound, like when you ask a bunch of questions in one, or leading questions like, "Isn't it true that you drew your gun for the purpose of killing that victim?" Right? That's a leading question, and it's also hostile. It's also sort of argumentative, ambiguous or vague if it doesn't make a lot of sense. So before I do a deposition, I always tell people, don't guess, you can estimate, and we'll get into that in a minute. And then if it misstates the testimony, like, "Isn't it true that you said earlier that Bill slapped Susie," when he never said that? Objection, misstates the testimony. You have to get your objections on the record, because objections not made are not preserved for the appeal or for admissibility at trial during the motions in limine phase, where you would try to restrict statements or evidence prior to the trial. So motions in limine are very important. And of course, if a motion in limine is granted improperly, that's an issue for appeal as well, for reversal. Asked and answered, if somebody keeps asking a question, hoping they'll get the same answer, you can object and say asked and answered. And even if they change their statement, since it was already asked and answered earlier, the testimony will be restricted, hopefully by the trial court, to the original answer. So that's something you need to know. Privilege. Now, objections on the ground of attorney-client privilege, work product doctrine, doctor-patient are crucial, including priest-penitent, okay? And if not made, these objections are waived, typically. And when I have an objection like that, when my witness is on the stand, I will instruct my client not to answer. That's about the only time, with very few exceptions, that the deponent isn't allowed to answer. So that's really important. So let me just really quick. I want to get through this really quick. Harassment. If it's an argumentative, objection, argumentative. If the questions are intended to harass or annoy or embarrass, if it gets too bad, you can stop the deposition and seek a court order. That's another thing we can talk about another time. You can seek doomsday sanctions, which would be issue sanctions or something like that, where you could even like have a whole defense stricken if it gets too bad. So that's very advanced, and that's something that if you guys really want me to get into it, that's like another 1 hour deposition. Not deposition, Jiminy Christmas. That's like another 1 hour YouTube video. So now, relevancy objections in California, they're pretty much not allowed. So a deposition is basically what's called a fishing expedition, okay? Just because it's not admissible at trial doesn't mean it won't lead to evidence that could be admissible at trial, okay? And the seminal case on that, I'm going to drop it in the sidebar for you guys if you're in California. For any of you guys who really give a crap, because I'm assuming that a lot of you guys want to learn, so I'm going to drop it here for you. That's the Stewart case. Hey, Life Under the Microscope, good seeing you, man. So that would be the Stewart case. So that's the seminal case in California. And there's a few other ones. Let me see here. But typically, in depositions, it's very broad. So under California Code of Civil Procedure, 2025.460C, which I'm going to also drop for you. And if you guys really want to learn, I'm trying to teach you guys what I know. So hopefully, hopefully you guys like what I'm telling you. So typically, if you making objections about the competency of a deponent after they've already been deemed competent to testify. So basically, a deponent is competent to testify if they haven't been declared mentally incompetent by a court, right, or a hospital, right? if they're not drunk. So I always ask at the beginning of the deposition, have you had any substances, any alcohol? Have you had any narcotics, even if they're legal or illegal? Is there anything preventing you today from giving the most accurate and competent testimony that you can give? And of course, that's a very compound question. So typically opposing counsel could object to that. And if they do, it's just going to make the deposition take longer. But typically a question like that, it's pretty much universal that they'll allow it. Otherwise, I'll have to break it down. Have you anything to drink today? Answer. Have you any illegal narcotics today? Answer, right? Have you had any legal narcotics today? Is there anything preventing you from giving your most accurate testimony today? Right? That's how you do it, right? That will be that, but that takes longer. As I could throw it all in one question. So if you have a decent working relationship with opposing counsel, it's easier. And there's no reason to have a hostile relationship with opposing counsel, right? Because if you're a good lawyer, you're going to be civil. And the best way to win a case is to kill them with kindness, guys. You don't have to be a dick. You don't have to cuss and swear. Typically, it's disarming, and it really, really, especially these narcissistic, people who practice law, it really, when you don't react to their insults and their asinine comments, it totally strips them of all their power, and it's like green kryptonite to Superman. All right. Well, give me a bunch of ones if you understand what I just said. If not, ask me to explain further, and I'll do my best as I look at the sidebar. So typically, relevancy objections and objections to competency, especially if you pre-qualified them as being competent, those you do not have to make those objections. And why? Because they're never waived. Relevance objections are always valid at trial. They're just not valid at the deposition, because those questions that I'm asking you at that deposition, even though I know they're not going to be able to come in at trial, it could lead to some other testimony or evidence or information or documents or things that could be admissible at trial. And that's what it's all about. It's about, it might be the fruit of the poisonous tree, right? But it might not be. It might be something that's open and obvious that could lead to something powerful that could help you settle the case or get the case dismissed, depending on what side you're on, or win your case. Hopefully you guys understand that. Okay, so here's some other case law. Rifkin versus Superior Court. It's 1994 case, 22 Calat 4th, 1255. Let me drop that for you California folks. All right. And let's see here. There's also Gonzalez versus Superior Court. It's, hold on, let me drop that for you as well. This is a case that further supports the broad scope of discovery questions at depositions. And that's all that a deposition is. It's discovery. You're just trying to discover things that could help you win your case or get the case dismissed, depending on whose team you're on, right? So there's that. Now, in California and in Texas, you have a wide latitude in questioning. So relevance objections are seen as pretty much obstructive. And when somebody starts making a bunch of objections like that, I will sometimes top the deposition and get a court order and seek sanctions. And I've been very successful at that, especially when they start telling me that where I'm at, judges don't do that. And it's like, oh, really? So you're speaking for the judge, right? I'll turn it around and I'll get that on the record. And the judge will be pissed because, the judges don't like it when people do stuff like that. All right. So now that we've sort of covered the types of objections, oh, by the way, I can also seek what are called doomsday sanctions. So if they don't answer, here's another one. Fifth Amendment type questions, like I have a right not to incriminate myself. If you're suing someone, as a general rule, you do not have the right to make Fifth Amendment objections. So if you're trying to say, I don't want to incriminate myself, those objections are typically not going to be allowed. And I can seek what's called the doomsday sanction, or a terminating sanction, to have your defenses or even your causes of action thrown out, and then ultimately get a judgment on the pleadings, basically that you don't have any valid causes of action because you've refused to answer questions. And then that falls in line with Evidence Code Section 412, which basically says that when stronger and more powerful evidence was within your grasp, but you didn't produce it, anything that you do produce shall be viewed with distrust by the jury. And so just think about that. So don't think that you can sue someone and then plead the fifth whenever they ask you uncomfortable questions. So I've seen a lot of cases get thrown out because these arrogant plaintiffs do stupid stuff like that. And then conversely, on the civil side, with a police officer, if they start trying to plead the fifth in a civil case, they're in potential real trouble, because I could try to move for summary judgment because they're not being truthful or answering questions. Now, whether or not they could potentially be, criminally prosecuted, it's really up to the judge at that point. And then what normally would happen is, because they have so much, immunity, right? Qualified immunity, or even sovereign, depending on what jurisdiction you're in, we would file a motion to compel that testimony. And we would seek sanctions, including but not limited to like terminating sanctions, to terminate their defenses. And then what we would normally do is the judge would have a hearing in camera. And all that means is he'll view it in private, in camp, like with the camera. It's so dumb. But it's just all about, using big words, Latin words, and things like that, because that's how we justify our paychecks. Oh my gosh, Chevy. Thank you so much, guys. Give me a bunch of ones for Chevy. Chevy's also been having some health issues, I think, kind of like me. Like, I've been on my back, and I know that Chevy's not a rich dude. So $10 from Chevy would be like, $1,000 from one of you rich dudes. So that means a lot to me, Chevy. Thank you for supporting Team MPE and helping me keep my channel going. It really means a lot to me, brother. Guys, give me a bunch of ones for Chevy donating. Look, even if it's $1, it doesn't really matter to me. It really means a lot to me that you guys are supporting my channel, because it really motivates me to come back, when I know that people actually give a shit about the stuff that I'm talking about. Okay, so now that we've gotten that out of the way, so now hopefully give me a bunch of ones if you understand some of the basic objections and that you understand some of the procedural posturing involved in a depo. Now, the next thing is proper foundation. So when I typically start out a deposition and set it up, I'm going to ask them their name, their date of birth. I'm going to make sure they're not on drugs, right? I'm going to make sure that they admit that they're not high, because if you're high, it's not your best testimony, right? I'm going to make sure that they know the difference between an estimate and a guess, okay? So the way I would typically handle this is I would say, Mr. Anderson, do you know the difference between an estimate or a guess? And they'll typically say, oh, yeah, I do. Okay, well, I'm going to tell you what it means from my perspective and from the court's perspective. A guess, it would be my desk right here that I'm sitting in front of. You've never seen it before, right? You get them to say, yes, I've never seen it. Okay, so you couldn't estimate how big my desk is, could you? Well, I don't know what you mean. Okay, well, let me explain further. You don't know how big my desk is. You haven't visually seen it. So if you were to tell me how big my desk is, that would be a guess, right? Yes, it would be a guess. Okay, great. And by the way, please don't shake your head up or down or say or nah, left or right. I need you to say yes, no, or I don't know, because this is going to be used for court. Do you understand? And make them say that they understand. Then move on. Okay, but the desk that's in front of you, you don't have a tape measure, do you? No. Get them to say, no, they don't. Okay, but you're a smart guy, right? Yeah, I'm pretty smart. Okay. So you could probably estimate how big the desk is in front of you, right? Yeah. How big do you think, by your estimation, the desk is that you're sitting at? Oh, about 6 foot by 4 foot. Okay, that's an estimate. So I'm entitled to your best estimate, even if you don't know exactly how big that desk is. I don't want you to guess, okay? And here's why. I don't want you to guess. Do you understand? Yes. Well, here's why I don't want you to guess. Because this testimony could potentially be used later at trial. And the judge, you're going to have a right to make changes to your deposition transcript later. And if you make changes later, the judge or me or opposing counsel or another lawyer, if I'm not trying the case, maybe I hire a trial lawyer, can then question your credibility. And all of your statements and everything you say could potentially be called into question if you change anything in your testimony later. Do you understand? Yes. Okay, perfect. So now that you understand the difference between a guess, right, and an estimate, I'm entitled to your best estimate. And in order for me to make sure that that you give me your best estimate, if you don't know the exact answer, right? We both have to understand each other. And that's why I don't want you to shake your head left or right or up or down or go, nah. Okay. I want you to say yes, no. And if you don't know, I don't know. I don't want you to guess. Okay. Do you understand? Yes. Okay. Awesome. Okay. All right. Let's move forward now with the questioning. That's how I set it up. Okay, guys, do you understand so far? Hopefully you understand. Right. Well, Bill Cooper, shaking your head could mean no. The problem is typically depositions aren't recorded on video. So it's going to be taken down by a court reporter. And a court reporter and a lot of my deponents, people I depose, are people from third world countries, illegal aliens, or cops who use highly technical language. So we just need to use basic verbal responses at a deposition. Do you understand? Give me a bunch of ones if you understand. Give me a bunch of twos if you don't. Don't say nah. Is this kind of making sense? I'm trying to help you guys think like a lawyer, because if you guys are doing pro per cases and you got to take depositions, this is good stuff to know. It really is. It's really, really good stuff to know. Hey, Free Palestine, what's going on, buddy? So we've got it looks like a Marxist commie, Free Palestine. Hey, Life Under the Microscope, good seeing you, man. Dawuda Shah, great seeing you. All right, so let's get into the actual video now of the deposition. This is a rare case where we have an actual video recording of a deposition. And so what I'm going to do is, as this deposition proceeds, I'll stop it at times and sort of tell you like my opinions and conclusions of how I may have asked a question or how I may have objected, if depending on whatever side that I was on, or how I would respond to an objection if an objection was made. Okay, so just bear with me, and hopefully you guys will have a good time, because this is the kind of stuff that I like to do, as opposed to just playing a bunch of videos of cops pulling people out of their cars and beating them up and stuff. So here we go. All right.
Goal at this point is to control him, get his hands up, get him complying. That's my goal. I see him, his eyes are just as big as $half or even bigger, just like a deer in a headlight. And then I see him playing, fumbling, doing something in his lap. There's none of this. There's none of this. It's this. And he's looking at me the whole time. And then. Okay,
so right off the bat, I would object and say, I need you to verbalize your responses. I understand that this is being videotaped, and let the record reflect that Officer, what's this guy's name? I'll just call him Officer Daytona. Well, hold on a minute. Let me just get his name. Officer Messerow. All right. Let the record reflect that Officer Messerow is pumping his arms and fists up and down, left and right. And Officer Messerow, I'm gonna go ahead and caution you to please verbalize your responses. Okay, here we go.
It happens.
What happened?
He sticks the gun out the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would so he just went just like that.
Okay.
And it was between the.
Okay. Again, I'm going to have to ask you to verbalize again, officer. It appears as though you took your right hand and pointed a finger in the shape of a firearm. Is that a fair statement? Okay. And again, I caution you, I'm going to have to cut the deposition short and seek a motion to compel verbal responses. Irrespective of whether or not this is being videotaped, the court reporter cannot officiate. The court reporter cannot take down non-verbal responses. Do you understand? Okay, here we go.
Mirror and the A post.
Okay.
Well, actually, if I'm driving.
Exactly.
I'm sorry. If I'm driving, the driver's side the door is here. So he did this.
Okay. Because you had him move in.
Okay, again, let the officer, I'm going to caution you again. It appears as though you are using your left hand to make a furtive movement that makes it appear as though you're grabbing something. And again, officer, I need you to verbalize what you are trying to reflect in imagery. And in this particular case, I need you to verbalize it and let the record reflect that it appears as though the officer is motioning with his left arm as though he's doing something with his left arm, which is vague, ambiguous, and unintelligible for the record. So I object on the basis that it's vague, ambiguous, and unintelligible, and it doesn't make sense. Counsel, can you please instruct your client to answer the questions verbally? Here we go.
Being
Excuse me.
further into the
No.
passenger compartment.
No, that was
to the
completely,
right.
that was my mix up in the side. It was the right side that he did it with, and then he put the gun between the window and the A post.
You said right side again.
Left side.
Again, let the record reflect that the officer is still not verbalizing, and he has taken his left finger and appears to have made it try to look like a firearm, but I just don't know. It's vague. So objection on his response, vague, ambiguous, and unintelligible. Counsel, can you please instruct the officer to properly respond to the question?
I'm dyslexic.
Are you dyslexic?
No,
Okay.
I'm sorry. I didn't. That was a bad joke.
What did you do at that point?
I let a round off at the suspect.
Okay. Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least one, and possibly two. I can't count them. I can't tell you how many exactly I saw.
This was before you fell.
Yes.
Okay. And then after you fell, how many muzzle flashes did you see?
4.
Several.
Okay. And I remember you saying at some point that you heard dink dink or dink dink dink.
So I would object on the grounds that the response is vague and ambiguous. I asked you how many muzzle flashes you saw. Several doesn't really cut it for me. How many shots do you estimate? 1? Was it less than 4? Was it less than 5? Was it less than 6? I'm entitled to your best estimate. Several is vague and ambiguous, officer. Counsel, can you please instruct the officer to answer the question?
You heard shots land around you. Is that a correct reflection?
That's correct.
Okay. How many times did you hear some evidence of something hitting around you, meaning that bullet being fired around you?
At
Jody!
least once or twice.
Okay. If a gun misfires and no projectile goes out, is
It's a
there
good objection.
No.
Good objection, Kyle.
I was committed to engaging him, and I did that. At which point, my ankle rolled off the curb, and I fell on my back.
Okay.
A lot of people do it, so like they don't mean to do it.
So, by the way, Kyle, let me just throw something out at you. It sounds like this is the plaintiff's lawyer suing him for a civil rights violation. So I guess I probably should object to his questions too, but being a plaintiff's attorney, I really want him to stick it to this guy. But so do you guys want me to make objections to his questions as well? Because I could do that. I was more trying to object to the way the officer was being, evasive. But yeah, I guess you're right. Okay, Kyle, that's fine. It's gonna take a while. This is gonna be a long show, guys. So dig in. And honestly, Kyle, form really isn't the best objection because it's a vague objection. You really need to be more specific. Is it compound? Is it disjunctive? Is it conjunctive? Is it privileged? What is it? What is the basis of your objection? Because, most judges, if you try to move in limine and get deposition testimony stricken at time of trial, like before the trial, the judge is going to be like, what the fuck did you mean by form? I mean, that could be anything. So just something to think about. But okay, guys, yeah, I'll do that. Hey, Jody, good seeing you. Right on. I got all my buddies here. We got 230 people in the chat, guys. That's pretty sick. Make sure to tap that like and subscribe button, everybody, and support Team MPE. You're never going to get anybody, you're not going to get a lawyer with 20 years experience doing this kind of stuff. I guarantee you that. I don't know. I have not seen any videos that do any of the kind of cool stuff that we do over here at Team MPE at all. And I'm sure you guys can admit that. Give me a bunch of ones if you agree. Here we go.
But this was a happenstance that had happened of like a kind of a mechanism of how I was falling. I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. Do you know by the time that you fell how many shots you had fired?
4.
And what did you have to do to alleviate the jam of the gun?
I chose to do a combat reload.
So, objection assumes facts, not an evidence. Okay, leading. Okay, because I'm going to pretend like I'm both sides. Okay, so don't think that I love the cop. Okay, I'm just trying to present both sides. So I would say for sure he's assuming that he did something at all to alleviate the jam. All right. And typically, by the way, guys, I'm a firearms expert. I guarantee you I'm a better shooter than this cop. What we would call is tap, roll, rack, okay? Tap, roll, rack. Tap, roll, rack, and because you want to get that jam out, all right? That's what it's called. He calls it a combat whatever, but let's listen to what he's got to say.
Which is just basically put another magazine in.
Okay.
Clear the malfunction and put another mag in.
Okay. Were you being fired upon at that point?
I wouldn't do that. I would leave the mag in.
He had the gun out the window, and he was pulling the trigger.
I think you indicated that while you were down or falling, there were several rounds that were fired at you, or you saw several muzzle flashes?
Yes.
Okay.
Objection assumes facts, not an evidence, misstates the testimony. There's no record before us that stipulates to any of that information. Okay, let's keep going.
How do you define several?
Objective form.
Objective form. Heard that?
2 probably.
Okay. Several's not one.
Yeah.
We agree to that. Do you mean is several more than 2?
Objective form.
I would say 2.
Okay.
So we'll say a couple.
Okay. Are those the shots that you heard around you,
Objective form.
land around you? Or were there other shots that you heard land around you?
Objective form.
My perception.
You can hear the objective forms. I'm going to let him ask these questions.
Those were the shots that landed around you?
Yes.
Okay. I'm just trying to understand how many times you recall that gun being fired. And I've got about 2, and then at a separate timeline, a little further down, several, but now that several's 2 as well. Is that accurate?
Can I look in this deposition?
Sure. You want to refresh your recollection of what
Sure,
you said
that'd
prior?
be great.
That's fine.
Yeah, it's totally fine. I want him to do that because I don't want there to be, hold on a minute. I don't want there to be any question later at trial that he can go, oh, he wouldn't let me look at the deposition answers or whatever, right? I want to make sure that he gives his best testimony so he can't weasel his way out of this case at trial. Give me a bunch of ones if you agree and if you understand my thought process at a deposition so far. Let's go. Why is it that cops are so out of shape? Kind of a disgrace, in my opinion. If I was a cop, I'd look like a freaking stud, man. Like I kind of do now, right? I'm in better shape than 99% of cops. I don't get it. You should be proud of yourself and, keep yourself in shape. Yeah, I agree with you, Jeff. But by the way, Jeff, I'm all sleeved out myself.
Doesn't specify. It says that I heard tick, tick, tick on the pavement.
In your deposition, you discussed dust. Tell me about that.
Form.
Was there dust?
Okay, so here's something that I'm not quite understanding. Typically, you take one deposition of a deponent. So it sounds like there may have been a criminal deposition taken for whatever reason in this state or Florida. Maybe that's allowed. It probably is. I know it's allowed in California typically, or Texas. And now what they're doing is they're using his criminal. I'm just assuming. I'm assuming facts, not an evidence. That they're using his criminal deposition testimony to try and impeach him, and he's using his criminal deposition testimony to refresh his recollection, which is totally allowed. Now, sometimes when a deposition's taking too long, we'll agree to a deposition part 2. So this could be a deposition part 2 of the civil case. I'm just trying to throw out some scenarios so you'll understand. It's without me knowing more, and I have not spoken to his counsel. This is an old case. I don't even know what the outcome was. I was listening to this in my truck as I was taking my daughter out earlier today, and I was like, man, this would be a really great exemplar to show Team MPE so they can understand. So let's keep going.
Dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes. From the suspect's vehicle spinning in the grass, which was dry, created a plume of dust.
Okay.
Thanks, Gates. I could use some donations. I haven't gotten anything for 2 weeks.
Did the dust settle? What do we say? Before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
Did it affect your visibility?
No. The spotlight on my vehicle I was able to really quickly ascertain what was going on through the dust.
Okay.
And I would say, can you please clarify what you mean, ascertain what was going on? It's a little bit of a vague response, officer. Can you please narrow that down? What do you mean by ascertain what was going on?
When did the dust settle?
Objective form.
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. And by dust settling, I mean it going back to the ground.
Correct. I mean, it was in the air.
You're just being a
the whole
smart
time.
ass.
Okay. Because this was about a 30-second deal.
Correct.
So the dust was staying in the air. Okay. My understanding that this guy named Bynum was trying to Marvin Jones had an outstanding warrant out of state. Were you aware of that?
Yes, I was.
Were you aware of that at the time?
No.
Okay. When you went to pull over,
Actually, strike that. Yes, I was aware of that.
Strike that.
let me back up then. When you went to pull over the Lincoln,
My God.
did you run the tag?
Yes, I called a tag out.
Okay. And what response did you get?
I can't remember that.
Okay. Did you, before you engaged, before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out, say that he was going to be at. This is the story I got. Say that he was going to be at picking this girl up at the airport, and he was in this vehicle.
Okay, so you knew that before you got out of your car.
That was hubbub on the radio prior to even engaging him. Anybody engaging him.
Can you please describe what hubbub is for the record, please?
Okay, what do you mean hubbub on the radio?
Oh, that's
That
good.
was talk on the radio. That was, I think that came in at the same time that We were learning that information the same time the whole gun incident happened in the airport.
That there was somebody, tell me again, or tell me what you heard.
That there was a guy waving a gun, and that this person, like I said, it was learned all at the same time that he had possible felony warrants out of New Hampshire.
Objection, move to strike. There's no evidence on the record that this is the same individual.
Okay.
If I remember correctly.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
Objection, calls for an expert opinion in conclusion. The deponent has not been qualified or sworn as an expert.
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
Objection, calls for speculation, vague, ambiguous, and unintelligible as to threat.
There was none.
What threat to an officer or other was posed when you got out of your car?
Same objection.
When you took a step towards the Lincoln?
Objection, compound, disjunctive, and conjunctive.
Objective one.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on us, making very furtive movements.
Okay.
Kept looking at me.
Objection, move to strike the answer, vague and ambiguous. I need you to describe, officer, what you mean. You're using a lot of street vernacular that a jury will not be able to properly interpret.
Very suspicious.
Okay.
Objection, vague and ambiguous as to suspicious. Move to strike.
Have you ever been reprimanded or even so much as sat down and talked to involving any insensitivities or issues related to race?
Objective one.
I was accused.
Objection, compound, disjunctive, and conjunctive. Calls for an expert opinion, leading, argumentative.
One time
What happened?
to the venue. She couldn't drive her car down there, and she was just pitching a huge fit. So she.
Objection, move to strike the testimony. It's argumentative. I'm going to petition the court to call the deponent under 776 of the evidence code as a hostile witness. Counsel, unless you can instruct the officer to answer the questions within normal English vernacular. Thank you.
Fabricated a story, and it was that we were racist.
Okay.
And that we had several times called her because she accused him of the same thing. And it wasn't a race thing like they made it out to be. It was just the fact that you're young, you haven't really done anything.
Rather than object, I'm just going to ask you, can you please define what you mean by race thing, officer? It's very vague. The record's not clear.
And it ended up where he was putting his finger in my chest, touching me, telling me I'm going to respect him because I got a badge. He said, I got a badge and you're going to respect me. That ended up into a shove by me. He came back. We ended up tussling. I mean, he's a relatively smaller kid. I had the complete physical and weight advantage on him. There was never any punches thrown.
I believe that.
It was a physical shoving match that when he
wins the Winchell's Donut Prize for being an obese, disgusting, fat body. Give me a bunch of ones if you agree.
He speared me. His head went in here. Of course, I grabbed him. And then there's the bruises came from there's wooden benches in the locker room. Well, I could feel his head bouncing off that wood as we hit the ground because I had no control. At one point, he hit his emergency button on his radio, basically saying to come help me because I'm getting my butt kicked by Mercero. And that was it. I mean, I said, "Are we done?" He says, "Yeah, we're done." And and again, it was all about respect with him. All about respect. He played the victim card very well.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What is-
And it also calls for a conclusion and an expert opinion. I mean, again, I'm not supporting the officer. I'm just saying, like, if I was the other attorney, I would be like, it calls for an expert opinion. There's no evidence before us as to why. And I don't know why. I mean, if I was the deponent, I would be like, I don't know. I don't understand why either. I'd like to find out from my supervisor. That's how I would handle it if I was him.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me
Because your dog got him.
because we got them as a team.
Okay. How was that communicated to you that you were being disciplined because of use of the canine?
There you go.
Some kind of
Form of objection. Go ahead.
bite ratio. I don't know. There's a national bite ratio, 30%. And if you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension.
That's
So
amazing.
they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say,
Should?
which never made any sense to me.
Can you tell us what evidence you have?
When was your
that's
canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Okay. December 23rd. Why does that date stick out?
Worst day of my life.
So these questions, by the way, these are foundational questions to establish his character for honesty and integrity and his background in disciplinary issues. And typically, I would file a pitches motion in a criminal case before the civil case even happened to try and pull up prior similar incidents of him being violent towards other potential alleged offenders or defendants. And here, I would always want to take a videotape deposition. And why is that? Well, look at his demeanor. I mean, if I was on the jury, and give me a bunch of ones if you think he comes off extremely arrogant. Give me a bunch of twos if you think he comes off like good to go, squared away, honest. Like, give me a bunch of ones if you think he comes off extremely arrogant, because demeanor is something that you really can't write down into a deposition transcript. And why do you think he has this demeanor? Well, here's why. Because the original court found when the original civil case got dismissed, they found that he was entitled to what? Qualified immunity. So because he's got qualified immunity, he gets to be arrogant. So that's where I agree about, OTVO, overturned Terry versus Ohio, guys. Give me a bunch of OTVOs in the sidebar, because I think a lot of this arrogance would go away if it was overturned. Here we go.
I enjoyed the job. I would have paid the city to come do that job, tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Objective form.
Never. I take that back. I bit a victim one time because she jumped in front of me. So
yeah, did you apprehend good guys? Yeah, I would say objection, argumentative. Objection assumes facts, not an evidence. But it is a question, so he's not really assuming. But it's definitely argumentative. But it's definitely vague, ambiguous, and unintelligible. Please define what you mean by good guys. Please define what you mean by bad guys. Is a bad guy someone that you arrested who was later convicted? How many bad guys, if so, how many bad guys have you arrested whose cases were either dismissed or who were overturned with not guilty verdicts by a jury? And in the third category, I would ask, how many cases are you aware of that where the victim or the accused or the defendant's case was given what's called a finding of factual innocence? Oh, you don't know? Objection. Move to strike his answers because he has zero foundation. There is no evidence before us that would allow him to make that statement. Is that a guess or an estimate? Are you guessing that they were never convicted? How do you know that they were never convicted? Oh, you don't know. Objection. Move to strike the answer. Move to call this deponent as a hostile witness under 776. These are nonsensical responses, and I want a court to decide this during the motions in limine stage. Do you have any objections, counsel?
I did. I bet a victim one time.
Was that another officer?
Oh my
No, it
gosh.
was a victim, a domestic violence victim.
Thanks, Kyle.
Was there an officer bitten?
Never. I've never bitten.
Guys, give me a bunch of ones for Kyle hooking me up with a freaking super chat. Let me see what he has to say, by the way. So Kyle says for a dozen donuts, $9.99 for a dozen donuts. Thank you, guys. Thank you, Kyle, for the donation. I really love it when you guys look, even if it's $1, I'll stop everything and discuss your chat. Guys, make sure to like and subscribe to Kyle's channel, and Adam is a friend. And as always, before we move forward, look, this channel is about creating parallel systems. I don't believe in participating in the administrative state or the bureaucracy. I believe that all of us are sovereign, and we should all be forming parallel systems where we help one another with our businesses and our families, that we homeschool our children, that we homestead, we grow our own food, and that we get off of the administrative state. We reject wholeheartedly what the computer chips, the shots that they want to give us, that we allow our bodies to engage in natural healing, and that we don't listen to people like the Faucis of this world, and that we go back to traditional medicine like the Amish. By the way, if anybody knows how many Amish people have autism, please let us know, because so far we haven't been able to find any. Anyways, let's move into the questioning.
An officer.
Okay.
My dog has never bitten an officer.
Right, and that's fine as long as we clarify it once. The one that was innocent, that was a domestic violence case, was that the one with the apple in her hand or something involving an apple? Or
No, that was another officer.
okay,
And if you knew her, the rhetoric behind her is the dog never bit her. The dog was trying to bite the apple in her hand. The dog never put teeth on her at all. He tried to grab the apple.
but she claimed that the dog did.
Objection. It assumes facts, not an evidence. What this called a move to strike the statement. What evidence do you have, officer, that that's the case? Have you been qualified as an expert witness in this case? Objection. Are you biased? I need to know more. Counsel, your client is answering questions as an expert witness, and he hasn't been qualified. I'm going to move to strike during the motions in limine phase.
But never injured.
Objection. Vague and ambiguous as to injury. Please clarify your answer.
Did she claim that is Ico?
Ico.
Ico. A-E.
E-I-K-O.
E-I-K-O. She claims Ico bit her.
Sure.
Okay. Right before this shooting, or before the incident involving Marvin Jones, there was an issue with an air card. What happened in that?
Check the form.
A new sergeant flexing his straps.
Yeah, I would say
that's what happened there.
I would say vague, ambiguous, and unintelligible as to what happened in that. Yeah. Overly broad. I would say definitely it's overly broad. Let me see what other ones could I make. I could definitely say that it's overly broad. I could say that it's misstatement of its testimony. Definitely compound, disjunctive, conjunctive, leading. So typically when you say objection to form, what that really means, form falls into several categories. It falls into compound, leading, ambiguous or vague, misstating testimony, or asked and answer. So making a broad objection as to form, it's not specific enough for many judges to uphold the objection. So keep that in mind. Objection to form is a lazy man's way to object to a question. Just keep that in mind, guys. Hey, right on, Just Willie. Everybody give me a bunch of ones for Just Willie. Definitely donut fat. I agree, dude. To me, I think that overweight cops are a freaking disgrace. In the Marine Corps, when I was in, it was back in '89. If you were a disgusting fat body, you got your walking papers. To be in uniform and to represent the interests of your community, you need to look squared away. You need to be able to run and jump over a fence and not just be someone who's a donut eater. And I just think it's terrible what's happened, especially to our military under Obama and Biden, where they just let these fat, disgusting people into our military, dragging down, dudes wearing dresses, all that stuff. Give me a bunch of ones if you agree that's ridiculous. Let's get back into it.
A new sergeant flexing his stripes.
What does that mean?
It means he had power now, and he was going to he was going to do whatever he was going to do. It was an email that could have been cleared up with a phone call. An email that I deleted because I don't know anything about an air card. I was told to take an air card from a computer in the computer lab from the computer girl. I took it. I wrote it down. I documented it. She said, just keep that one. I'm going to put another one in there. Well, in the meantime, this new sergeant is trying to find this air card, and he puts an email out, a department-wide email. Well, I don't know anything about a stolen air card, so I hit delete. Well, the next thing I know, he's sending me second and third emails. Well, now I'm reading them, and I replied back to him, but he still wrote me up for insubordination.
Do you recall in 2011 a person named Justin Riddle claiming you did an unauthorized strip search or use of force on them?
Objection. Vague, ambiguous, and unintelligible as to strip search. Leading. Speculative, calls for speculation. But you can then the other attorney would say it's okay. You can answer. So keep in mind, I can make all these objections, or the other side can make objections, but unless it's a privilege objection, the deponent still has to answer. That's very important for you to understand, because I can still move in limine prior to the trial to have that deposition stricken, that testimony stricken, based upon my objection. So just so you guys understand that.
Yes, sir.
Tell me about that one.
On Mason Avenue?
I think so. Tell me about what you recall.
I don't recall much of that. Other than dopers hide. They're dopers, criminals, people who sell drugs, hide their drugs under their testicles and in compartments in their underwear.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain?
Objection. Vague and ambiguous as to strip search. Vague and ambiguous and unintelligible as to supervisory authority.
Obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that until you did that portion incorrectly?
Objection. Compound, disjunctive, and conjunctive.
Yes, sir.
Okay. March 2011, there was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Objection. Assumes facts, not an evidence.
Tell me about that.
Objection.
Forget his name. He's from Tavares. He was, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident?
Objection. Leading. Vague, ambiguous, and unintelligible as to home, person, and I remember that.
What happened there?
I was on K9. We were looking for, they're twins. There's two of them. And I forget their names, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did.
No.
The one of them
had a felony warrant.
The guilty one, not the innocent one.
So the mother's there, and
Objection. Assumes facts, not an evidence as to guilty. There's no evidence at all. It's argumentative. Assumes facts, not an evidence. Leading.
Got the place surrounded, and basically she said, "You're not coming in." Well, he's in there. We can see him in there. We can force entry on a felony warrant if we see the person and we confirm it's him. I eat that one. That was my responsibility all day long for not knowing that it's the brother. They do look different. If I had seen his face, maybe pay attention to his haircut. Yeah, that one was an unfortunate mistake on my part.
Okay, so just so you guys understand it sounds like what plaintiff's lawyer is trying to do is establish that there are prior similar incidents that are similar enough to where it can show a pattern or practice of this guy violating people's rights. And that would help build what's called a Monell claim. So you should Google that if you want to learn a little bit about civil rights. But if you can show a pattern or practice of similar past violations, you can build a Monell claim, and it makes it easier to prove your case, basically. And we can get into Monell claims at another date, but let's keep going.
Or not, I mean, I'm pretty wide. So whether or not she felt pressed up against the wall, it was nothing intentional.
Do you recall telling her something to the effect of, it wouldn't be pretty if she didn't get out of your way?
Yeah, maybe. I mean, I'm trying to get into this house to get this felon.
Would that be simple battery? Simple battery.
Objection calls for an expert opinion and assumes facts, not an evidence. What are you trying to ask him, counsel, by telling someone that their face could be changed? That's a battery, or that if they change their face, is that a battery? Can you please qualify the question, counsel? Thank you.
Objective form.
Yes. If a person touches somebody that's unwanted, or it could be considered resisting an officer. If that had been the brother, she could have gone to jail for resisting.
But it wasn't the brother, and she told you it wasn't the brother, right?
Correct.
Okay.
Correct. And to get paid for watching your dog. That's what they do. Some people before me and during my tenure as a canine handler, that's what they do. They'll back in somewhere and they'll wait for that burglar alarm, which happens 5 times a night. Other than that, they're watching a movie. That's not my way. It's not what I do.
What's your way?
My way is I did everything as a canine handler. It wouldn't be nothing out of the realm of me to go take a 43 retail theft. I wrote 10 tickets a night. That's on top of all my canine duties. So if there was a bad guy to be found, I was doing it. That's the guy. That's what I was
Can you please define what a bad guy is? Thank you.
doing.
Okay. Did you ever arrest a good guy?
Form.
Did I ever
Objection asked and answered. Leading.
arrest a good guy?
Vague, ambiguous, and unintelligible as to good guy. And then the other attorney would say, you can answer. And he can't answer. He has to answer.
Yeah.
Not that I can recall.
So Deputy Chief Bears, am I pronouncing that correct?
Bears.
Bears.
Yeah, Bears.
Oh,
Bears.
Okay. Issued you a memo about his perception of your misuse of canines. Is that a fair?
That's fair.
Okay. A fair characterization of that, not necessarily what you did or didn't do. Do you agree with that characterization?
Form.
Okay.
No, I don't. This comes from a liberal chain of command who got mad at me chasing a flea.
Can you please describe liberal? It sounds like you're using the term liberal in a way that's negative, like it's bad to be a liberal. Can you define what a liberal is to us? Thank you.
Felon into a dumpster. Empty dumpster. You jump in the dumpster, police canine, come on, I'm going to be dog bit. No answer. Okay.
You sent the dog in?
That's what he's for. I'm giving you warnings. So he just made such a big deal about why didn't I do something different? Oh, like shake the dumpster upside down. What do you want me to do? I mean, that's the kind of thing that I was dealing with every decision I made to dog bite somebody, there could have been a better answer from a certain captain or a certain two captains at that time. Like there could have been something else could have been done. And they exploited that. And I mean, it was horrific.
Is it fair to say that they want to keep the suspects safer?
Form.
Objection: vague, ambiguous, and unintelligible to safer.
I guess it's fair to say.
They want to preserve more of their civil rights?
Form.
And that's how cops
Objection: argumentative.
get killed. Second guessing themselves and not taking action when it should be taken.
Would a offender in a dumpster, what threat did an offender in a dumpster present to you?
Form.
If he had a gun, he could have been.
And that's true. You could definitely say, vague, ambiguous, and unintelligible is to form. You could also object on the grounds of compound, disjunctive, conjunctive. You're asking several questions in one. It's unintelligible. You just don't understand the question.
And there could have been a million different things go wrong in there.
Did you ever find out did you apprehend that offender?
I did.
Because of the dog?
Correct.
Was he armed?
No.
Explain for me what you mean by liberal chain of command.
Oh, there you go. Finally.
I guess to them, a dog biting a person was.
Move to strike. I don't want to guess. I want your answer, officer. I need you to tell me what you meant by that. Guessing is not allowed at a deposition.
Never okay. There was always another answer.
Is there? Do you disagree with that?
No, I don't.
Form.
No, I don't.
Okay. What else could have been done? Let's just stick with the dumpster. What else could have been done in that incident besides putting your dog in the dumpster to apprehend that individual?
Objective form.
Hindsight's always 20/20.
Okay. Would you say?
Yeah, I would say objection calls for an expert opinion and assumes facts that anything could have been done. That's how I would handle something like that, depending on what side of the aisle you're on, right?
If I asked you that question about the Marvin Jones incident,
Objective.
No, I wouldn't.
you wouldn't say hindsight's 20/20.
No, I wouldn't.
If you had to do it all over again, you wouldn't call a supervisor.
No, no,
You wouldn't coordinate with your fellow officers.
Objective form.
no, sir.
You would have in every
I would say objection is to coordinate. I would say objection argumentative.
replay of this, you would have Miss Bailey wind up paralyzed.
Objective form.
No, sir.
Objection argumentative. Come on, counsel. That's ridiculous. Don't ask my client questions like that. Paralyzed. Give me a break. Come on, man.
Okay.
So anyways, that's basically the way that you would handle a typical deposition. And I tried to present it from the point of view as both sides, like kind of give the POV of both sides without taking any one side. Even though, I don't like overweight, disgusting officers. I think that if you're going to be wearing a uniform, you need to be squared away. I think it's disgraceful for someone to be putting on a uniform who can't even run down a suspect, let alone hop a fence, living off of our tax dollars. That's ridiculous. Give me a bunch of ones if you agree. But beyond that, that was basically the way that I would handle it. And you guys have any questions? Because I'll be honest with you, my back is pretty jacked up, and I need to go take some pills and get the heating pad out and try to get squared away. By the way, guys, I have an MRI tomorrow. Give me some prayers and wish me luck that it's not too bad of a herniation, and so I can keep doing my shows. And I'm really grateful that you guys joined me tonight. I'll try to break up some shorts to share with you guys from this video throughout the week. So at least you guys will have some cool stuff about how to make a proper objection at a deposition for pro se idiots or for pro per idiots. And hopefully this will help guys that are out there on the front line, guys like Lane Myers, guys like Mr. Gold, guys like Chili DeCastro, guys like Reluctant Prophet, guys like BZ Watchdog, who are out there, at the tip of the spear every day, doing government accountability operations. And let's pray for all of them that they don't get shot in the process of just trying to hold the government accountable. Because, our First Amendment wasn't just written for religion or for someone with the press card. It was primarily designed so that we could hold our government accountable. Because you see what's going on now with Doge. I mean, you're seeing like all these money laundering operations by the far left where they're funneling money to the Ukraine, and the Ukraine is allegedly selling at least 40 to 60% of the weaponry on the black market, much of it to Russia. A lot of it's ending up with the drug cartels in Mexico. I mean, this just needs to stop. There's no constitutional authority for U.S. aid flooding our country with illegal aliens using government tax-funded nonprofit organizations to flood the United States of America with over 20 million illegal alien criminals who are immediately registered to vote at the Department of Motor Vehicles. And then they use them to try and change our voting districts using the U.S. Census data. What a disgrace. So give me a bunch of ones if you're glad we finally are starting to hold the government accountable, and we're firing a lot of these worthless government bureaucrats. And we'll get into that in another show. But they're technically arming bureaucrats. That's right, Beyond Watcher program. So anyways, hey, good seeing you, BZ. Right on, dude. So with that being said, I just want to thank everybody like I normally do. Thanks for joining me, Jody Shiloh. Thank you for joining me, Lou Kahal, Age Go. Thank you for joining me, Dar. I love Chili too, Dar. He's a legit dude. He's a good friend of mine. And I just am so glad he got out and that he got his case reversed and was vindicated. And all those scumbag frauditor people can go sit on their own face because he was innocent, and I knew he was innocent. And I visited him in jail and made sure that he knew people cared about him. Grateful Dabs, thank you. Thank you, Dawood, Wanda Mise, Just Willie. Let me see here. Grateful Dabs, I've already said it. Moma Birdie. BZ, as always, God bless you, my Marine brother. Signock 15. Free Palestine. Just Willie, Bobby Sands, Jacob Vargas. I'm trying to find all you guys that I've not said thank you to. Jason Kemper, Juan M. Vargas. I'm not going to do surgery, brother. I'm going to do everything that I can to. I've already got the teeter hang-ups. I've been doing the planks and the push-ups and everything that I can to try and keep my core strong. I'm not going to do that, bro. Marley's World. Kevin Biernowski, thank you for joining me. All you guys are so awesome, man. I'm so glad that you're all here. We got to do like a big seminar where we all come to Vegas and hang out sometime. Give me a bunch of ones if you guys all want to come out and hang out with me and Chili DeCastro and Dick Heller of Heller versus District of Columbia and just shoot the breeze. If you do, we'll try to arrange something. And then Kyle, of course, thank you as always. And Life Under the Microscope, thank you, brother, for everything. Thank you for introducing me to the carnivore diet. And John Lively, Santos Chavez, Mickey Crippy, SBS. What's up, brah? Got you, brother. Dar, Ant, Pasano, and Paisano. Good seeing you, my friend. Buonasera. I love it, man. Julian, Mr. Osgood, Brett Ray, Greg B. Man, all my buddies came and you still support me. I really appreciate it, guys. I'm sorry I haven't been around. I've got really bad sciatica, so I'm doing my best to do these shows right now. It's not been easy. And you guys are so awesome. So, and then Just Willie, thanks again for the donations, man. That even if it's $1, it really means a lot to me that you support my show. As you know, my law firm's trying to make a comeback from Governor Gavin Screw Everybody, destroying our law practice and during the lockdowns. And, I basically was able to make payroll and used all of my savings to cover all my employees. And now we were left basically with nothing. So we're trying to rebuild the firm. And again, I do catastrophic injury cases. So I do bad motorcycle accidents, trips and falls, police shootings, tight handcuff cases where you have an amputation of a finger or a wrist. And that's the kind of stuff that I do. And so if anybody of you wants to, send some business my way in California or Texas, I'm all about it. And if you have a legal matter that you need help with that I don't handle, I'll still try to help you find someone in your state. So, because I know a lot of my guys are in the UK or they're in Australia or Scotland, man, or they're in another like the left coast or something, or the East Coast, and I'm not able to represent them. But I'll try to help you find someone. I care about people more than anything. And my dad always told me, don't worry about the money. If you do a good job, the money will follow. And I think he was right. And I don't have any guilt at all about making sure all my employees were paid while our government destroyed so many businesses over something that had a 99.99% survival rate. Think about that. So with that being said, guys, please make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. So Semper Fi, do or die, everybody. God bless you. I'll try to come on tomorrow after my MRI if I can. But if I don't see you, thank you for supporting me. God bless you all.